Okay, it's my pleasure to welcome you all to this seminar that my colleague Panu will be giving to us today. Panu is our professor of jurisprudence here at the University of Helsinki, and there are at least two reasons as to why I wanted to invite him, and I'm very happy that he accepted. Well, the first reason is personal, in the sense that whenever I have a problem with my writing and I see any kind of a theoretical dimension to it, then it's on Panu's door that I knock, and I'm frequently there, and I try to explain it to him what I think, and then I come back. Usually what happens in that process is that Panu tells me what I actually think. He has sort of the ability to see what someone is trying to explain, but really cannot actually express very well, and helps you to see the theoretical and sort of structures in what you're trying to express, and that's tremendously useful. I learned from my PhD that is actually his special talent at the faculty, one of them. The second reason is that he's also run work in the area of separation of powers, and when Christina and Anna and I were designing the project, I came across a paper written by Panu on separation of powers. It's sadly written in Finnish, so I could not share it. But I thought already then that once we get the project started, maybe he could come and talk to us about it. However, we gave him a relatively free mandate, because I'm sort of confident that whatever he chooses to talk about will be useful. But I'm all ears, as I think we all are. Panu, the floor is yours.
Thank you very much. And first of all, thank you all for the invitation and for being here. It's a pleasure to be able to try to share these ideas with you. Today, sort of what I'm presenting today, sort of I hesitate to call this a lecture in any way, and indeed it is sort of like it's put together from bits and pieces that Panu mentioned, the article in Finnish, which was specifically on the separation of powers, but part of this is from another Finnish article on judicial activism, so forth. And then a third component may be a sort of more recent project on agonistic political theory and its sort of legal implications, which I've sort of like incorporated all together. So this may be a miss in the sense that I've never sort of put these components together in this way before, so this is the first time. It may sort of be merely a plan for a project that I haven't quite started yet, but sort of nonetheless, I hope that there's a narrative here that you can follow, and that the narrative also might provide you with some possible insights that you can utilize in your own work if you deal with sort of institutions and with interinstitutional relations, regardless of whether we're talking about statist environments or transnational environments and what have you. For the most part, because this is 45 minutes, sort of I'm not the sort of individual researcher who can speak 45 minutes without a paper. Right, so we know, each of us, we know we can watch, sort of like videos of Ronald Dworkin talking for 2 hours without papers at the Library of Congress in the US and so forth. But sort of, I don't belong to that type of person. So I need the papers here. Moreover, of course, sort of English it's not my mother tongue. For most of you, it's probably not your mother tongue. It's your strong second language and so forth. And I need the sort of backup, at least the backup of a paper here. Now, the basic idea behind my talk today is a take on the common idiom that our responses can only be as good as our questions allow. In this case, that take would be the following. So any account of the relationships between legal and political institutions in both statist and transnational or even trans-statist environments is always dependent on what the underlying theoretical premises of the study will allow. In the type of research that most of us do, these underlying premises can perhaps be shorthanded as liberalism. There are, of course, several variations of such liberal theories, but there are also enough common features to justify the use of the shorthand. One of those common features involves an ideal of interinstitutional relations. And allow me to illustrate this point with an image. And so I now share the screen for you for a second. This is my only slide. Yes. So this is an aerial photograph of the Three Powers Plaza in Brasilia, the federal capital of Brazil, as it was being completed in the early 1960s. So geometrically speaking, the plaza is not a square, as similar public spaces often are, but an almost equilateral triangle. So each corner of the triangle is occupied by a building representing one branch of Immanuel Kant's Trias Politica, the political trinity that is implied in a traditional separation of powers doctrine. The National Congress is the legislature here, if you see my cursor. At the top vertex, the presidential Planalto Palace is the executive on the right, and the Supreme Federal Court as the judiciary on the left. Now, the symbolic significance of the design can hardly be overstated. Imagine the same triangle as an organizational diagram familiar from textbooks representing the constitutional design of a statist or transnational entity and defining the roles of the respective branches and institutions. The legislature with its vertical position at the top of the triangle implying supreme power and authority, the executive putting legislation into effect on one side below it, and horizontally on the other side, the judiciary applying laws in individual cases. The space that lies in between the three vertices, so the actual plaza in the real world of Brasilia here, represents the unobstructed access that would allow each institution to oversee the activities of the others. Okay, so I will now stop sharing. Now, such a diagram is, of course, an idealization. It overdetermines the ways in which public power supposedly operates in a spatially ordered way, and how the reciprocal checks and balances are meant to temper that power. So in this liberal model, the interinstitutional oversight that the checks and balances provide supposedly also produces a balance that allows the statist or transnational entity to go about its business in a way that is deemed democratic. But perhaps the balance that is consequently achieved between the three persons of the political trinity masks their underlying tensions. We could, namely, understand that balance in game theoretical terms as a balance of power, or even a balance of terror, as it was called once, in which one institution reluctantly stays within certain bounds due to a fear of reprisals from another. So we can formulate a few hypothetical examples by building on the distinction often made between potentiality and actuality. We can ask, for instance, whether the executive has drafted its political and legislative agenda already with the legislature's potential criticism in mind, or if the legislature, as supreme as it may be with its democratic mandate, tempers its legislation because it anticipates what the judiciary may find unacceptable if the legislation in question was tested in constitutional review. The point here being that in interinstitutional relations, disagreement need not always actualize into open disputes. The institutions don't need to make their differences public, but the potentiality of disagreements is always there. When interinstitutional relations are potentially conflictual, they are also intrinsically agonistic. The Greek word agon translates into competition, contestation, strife, conflict, and related words. The agon was the competitive process through which the Greece of antiquity identified the best individuals, regardless of whether we were talking about military skills, sports, poetry recital, or political oratory. For many 19th century classicists and philosophers, the agon was the key element in the political success of Athenian Greece. In contemporary political theory, agonism, which sees politics essentially as an outcome of disagreement and contestation between different actors, is best known from the work of, for example, William E. Connolly, Bonnie Honig, and Chantal Mouffe. We can, with some reservations, even identify agonistic elements in constitutional theorist Carl Schmitt's friend-enemy distinction. It's a bit of a different thing, like, for example, Chantal Mouffe, who's an explicit agonist, also equally explicitly distances herself from Schmitt's sort of antagonistic friend-enemy distinction. But the main idea is that agonistic interinstitutional relations involve multiple actors with different and often incompatible interests that are played out in the exercise of public power. And this is the main point. Interinstitutional relations always involve the use of factual power, an element that is usually bracketed out in liberal accounts of the same phenomena. So before developing these ideas further, I need to take a few steps back to frame my arguments appropriately. Dutch-born political scientist Arend Lippard famously claimed that so-called consensual models of government based on proportional representation and coalition governments are more capable of promoting democratic values than governments based on a majoritarian Westminster model. In the latter, a political party that wins the elections usually gains an absolute majority in the legislature, after which the leader of the winning party, a prime minister or someone else, can with relative ease further her political agenda until the next elections. We can perhaps assume that Lippard's consensual ethos applies at least to some extent to interinstitutional relations as well. So meaning that even the institutions in question that we're sort of dealing with here would somehow require a sort of consensual framework for them to work properly. Political scientists have, however, pointed out that recent developments, especially after the terrorist attacks of 2001 and the subsequent prominence of security concerns, have shifted consensual models of government closer to strategically motivated political leadership and the premises of the Westminster model. So a prime minister is not only the chairperson of her parliamentary party, but also a political CEO who secures her agenda by leading her parliamentary majority with the help of a rigid culture of party discipline. And the aim of party discipline is to strengthen the strategic power of the leadership, that is the executive, in relation to individual parliamentarians. This type of model where the legislature is factually subjected to an executive that functions as the political engine of government is both typical and necessary in times that are deemed to be exceptional. Sort of like now, basically, with the pandemic, etc. This is, I guess, sort of like what we're all dealing with at this particular moment. But even historically speaking, American political historian Clinton Roster noted that the wartime UK government led by the Prime Minister achieved its prominent status already before the Second World War. So even though Parliament sat throughout the war period, its legislative duties had already diminished at the same rate as the government's powers had increased. So factually, the government acquired the possibility to function without the threat of no confidence motions and was practically free of all parliamentary scrutiny. And so this is probably something that we can see in current affairs all the time, sort of basically, especially in countries like the UK, where the majoritarian Westminster system is sort of is the model, the basic model on which it's based, where the prime minister more or less forcefully drives his agenda through parliament, forcing even his own backbenchers to comply. From the perspective of Western liberal democracies, the era after September 2001 has undoubtedly been exceptional in just this sense. Think of the new anti-terrorism measures adopted in several countries and the risks of new widespread pandemics is likely to strengthen these features further. While there are signs of more permanent changes in the governmental interinstitutional relations, the growing significance of the executive branch cannot be unambiguously attributed to the exceptional circumstances of the post-9/11 world and the new security concerns that it has brought about. So although there is more or less unanimous agreement on the increase of executive powers, especially in relation to the powers of the democratically elected legislatures, the reasons for this so-called constitutional crisis management are more varied. So the idea here is that political scientists, what they can do is they can show that there is a shift from these consensual models to more sort of Westminster type models in general, but they can't basically pinpoint it on security concerns post 9/11. So there are other sort of reasons for these changes as well. Claims concerning the increase of executive powers are still inferred from a traditional notion of the separation of powers doctrine and a tripartite institutional model that requires clearly distinguishable legislative and executive branches. But in many cases, we are factually dealing with a model where two institutional persons of the political trinity, namely the legislature and the executive, have merged into a single political superinstitution that German political scientist Winfried Stefani has termed a Regierungsmehrheit, literally a governmental majority. So a governmental majority refers to a single institutional entity, seldom explicitly mentioned in the constitutional framework, that includes a strong executive government pushing forward a political agenda with the support of its majority in an otherwise weakened legislature. In this sense, a Regierungsmehrheit resembles the English expression, the elected branches, that also conflates two institutions into one. A governmental majority can successfully draw on its democratic mandate insofar as the electorate is understood to have given its blessing to the party's political agenda. So the thing is that the idea here is that we understand that in elections, the electorate sort of votes on political programs that parties put forward, the agendas that parties put forward as to what they would do if they were in government. The executive then orchestrates all legislative matters by putting this political agenda into effect with the help of a legislature bound by a rigid culture of party discipline, as we've sort of seen in a number of different sort of cases. In terms of standard accounts of a separation of powers doctrine, this development seems to imply that we're gradually moving from textbook tripartite institutional models to more dualistic models in which we have two rather than three institutional entities: a governmental majority led by the executive or the elected branches, as they would call them in the UK, and the judiciary. This development echoes the more general shift from consensual models of government towards executive-led Westminsteresque models, that's a neologism, hence difficult to pronounce, of government mentioned earlier. In such a dualistic model, the relative position of the judiciary will have to change as well. If the traditional starting point of the tripartite separation was that a deferent judiciary primarily applied laws passed by a democratically elected legislature, its motivation for showing deference to an executive-driven governmental majority cannot be the same. Interinstitutional relations are always relative, meaning that changes in the position of one institution will always affect the others as well. So we can at least hypothesize that in such a dualistic model, the judiciary may eventually balance the scales by taking on democratic functions that a weakened rubber-stamped legislature has lost in the merge. From a liberal perspective, the shift in judicial power may seem worrying because it suggests a more activist position into which unelected courts move in relation to the elected branches. And in such a juxtaposition of two institutional entities, disagreement is always at least potential, sort of probably even sort of like actualizes more often than before. So what is the nature of judicial power in standard liberal accounts of the separation of power? Once again, I take a few steps back before proceeding. And this may be, you'll kindly excuse me if this is sort of known territory for you, but nevertheless, I did want to skip it so that the argument at least is clear. So Alexander Hamilton, one of the best-known founding fathers of the United States, famously wrote together with his colleagues James Madison and John Jay 85 newspaper articles known as the Federalist Papers to support the ratification process of the country's draft constitution. Hamilton penned the article known simply as number 78, which deals with the constitutional status of the judiciary. Hamilton claimed that the judiciary cannot be regarded as a threat if its powers are defined and delimited in a rigorous enough way. Judicial power did not extend to congressional lawmaking or to the president's executive powers. So the courts had no influence over, as he said, either the sword or the purse. This is why the judiciary is, in Hamilton's well-known expression, the least dangerous branch. Hamilton's allusion to dangerousness calls for at least two observations. The first has to do with the separation of powers doctrine in general and the judiciary's role in that separation in particular. Traditional accounts of the doctrine usually refer to a concern about public power being concentrated in too few hands. This is clearly sort of Montesquieu and Locke. So they both sort of like refer to the necessity for a separation from this particular point of view. The same concern was echoed by Hamilton's colleague James Madison, who in the article known as number 51, elaborated on the reciprocal mechanisms with which government branches would oversee each other's activities. In terms of the judiciary, such mechanisms of checks and balances referred primarily to the constitutional review of legislation passed by Congress and of presidential orders. Reciprocity, on the other hand, was based on the idea that if the Constitution assigned all institutions equally ambitious tasks, no single institution would be in an inferior position in relation to the others. So powers are not only separated, but also sort of reciprocally balanced. The whole idea that if the powers are equally ambitious for all the different institutions, we find this type of odd balance between them that supposedly then produces a democratic outcome. A second perspective would, at least at the outset, seem to be incompatible with the first. When Hamilton argues that the judiciary is the least dangerous branch, he seems to be calming fears of the opposite. So when would the judiciary then be dangerous? The institution using judicial power is deemed to be the least dangerous when it functions from a position of deference in relation to a democratically elected legislature. So judicial power implies a corresponding competence, which in turn suggests limits and boundaries that the judiciary is expected to respect. More generally, the idea of the least dangerous branch is a reference to the competence that the judiciary has been given in one statist or transnational constitutional framework or another that is usually limited to applying laws in individual cases. A competence always implies a power that is somehow limited by boundaries. This is sort of like one of the arguments that Carl Schmitt made in his Verfassungslehre, the point that there is no competence. You cannot have a competence because it's it's a logical impossibility. So this is sort of like competence always has limits. It's always limited one way or the other. So how would a dangerous judiciary then overstep the boundaries implied in its competence? Usually overstepping boundaries of judicial power would be expressed by claiming that the judiciary is meddling in political affairs that do not belong to the legal realm. The recent discussions concerning the role of the UK Supreme Court come to mind as an example. I mean, in Britain, they discuss a lot of these things. They argue a lot about the role of the courts and so forth. So in what circumstances could judicial power be considered political? And the word political can, of course, take on several meanings here. First, the judiciary is an institutional actor in the general framework that makes up a statist or transnational entity. So as one person of the political trinity, the judicial performs tasks that are significant for the trinity as a unitary political whole. In this sense, judicial power is undoubtedly also political. Second, the decisions that the judiciary makes will affect the rights and obligations of individuals and incorporated entities in profound ways that can with good reason be described as political. The courts make decisions on the allocation of resources and services, and they oversee the lawfulness of public authorities performing their functions. Third, individual judges can be seen as social and political influencers, as legal experts, as a very sort of prominent new book sort of like discusses the issue. They network among each other with politicians and with civil servants, and their views will factually influence the way in which political decisions are made. And even in this third sense, the judiciary is part of a larger political whole. Now, if these three descriptions about the judiciary being political are relatively benign, we do have more controversial variations as well. A political judiciary may, for example, refer to the makeup of the institution's key personnel, meaning that certain emphases, usually white, middle-class male, lead to corresponding judicial decisions, as the expression the judicial patriarchy implies. The lack of representativeness and the homogeneity of, as the case usually is, a white, middle-class, and male judiciary is a less desirable political aspect of judicial power. This is something, especially if we talk about, so this of course differs from country to country. In terms of gender or sex, we have in Finland, we have a situation where I think the majority of the judiciary of judges are now women, but there is a glass ceiling. So the higher up you go, the sort of smaller the proportion of women are, even though some have made it all the way to the top. This is certainly not true in a number of different countries where they have addressed the issue of making the judiciary more sort of representative of what society looks like. In Finland, our problem is getting the different sort of ethnic groups that we had, ethnic communities first interested in legal education, then becoming a lawyer, and then sort of basically sort of being represented in the judiciary as well. So there's a lot of work to do even at the grassroots level, just simply outreach work that we have to do in the local schools, etc., in the schools where, in areas where the sort of like ethnic communities sort of live. But simply sort of looking at a first year sort of cohort in the law school will already tell you that this is not sort of like, this is not a very representative group of what Finnish society is supposed to be like. I mean, they are, in our local lingo, they are all from South Helsinki, meaning that they are well-to-do, middle class, and of course, white. But the gender issue is sort of dealt with. There are more students, women students, than there are male students in Finland. So that's sort of like at least one of the things has been taken care of. The judiciary may also be political in the sense that its decisions are abused to directly advance the political positions held by one of its individual members or another. So this is the sort of like abuse of judicial power when you use the courts in order to further the political agenda that is your personal agenda, or you use it to sort of like, regardless of what your intentions are, you use the courts in order to further, for example, the well-being of where you're from, of your home county. So when I refer to the judiciary's activist tendencies at the borderline where legal decision-making reaches out towards the political, I'm primarily talking about the three first mentioned, more benign characterizations. Judicial power is always political to the extent that a strict separation of the legal from the political that positivist accounts of law still adhere to is neither possible nor desirable. By contrast, when the representatives of government accuse the judiciary of meddling with political affairs, they usually refer to the two latter and admittedly more problematic characterizations, even if those accusations are often merely rhetorical devices. So promoting social justice becomes a judge's personal political commitment that supposedly cannot be inferred from the principles embedded in law. It's a bit like, so you have a sort of like a liberal judge, as the English expression would go, or in Finland we would call them green left judges who sort of like promote certain values as if those values could not be extracted or constructed from legislation itself, regardless of whether we're talking about the environment or political rights or other such important matters. Be what may, the agonistic interinstitutional relations between the elected branches and the judiciary are often acted out in the name of judicial activism. So this is, it's sort of like the terrain where the judiciary is accused of activism, and sometimes indeed the judiciary does something or makes decisions that can be at least somehow associated with what is commonly understood as activism. Excuse me. The term itself, judicial activism, was apparently coined by American historian Arthur Schlesinger Jr. in a magazine article from 1947 that dealt with the US Supreme Court's internal politics in the post-Roosevelt era. In Schlesinger's account, the activists were legal realists of the Yale School, for whom the Supreme Court, and by extension the whole judiciary, had an important role to play in furthering social justice. Schlesinger called the other half of the court the champions of self-restraint, who were keener to merely see to it that the will of the legislator is fulfilled. If activism can be then identified with just results, self-restraint has more to do with the formality of due process. Often mentioned examples of judicial activism are an expansive use of constitutional review, overturning established precedent without sufficient justification, changes in generally accepted interpretive models, and the consequential justification of decisions from their results. Now, all these examples tell of a negative attitude towards judicial activism, typical of liberal theories, a position that is also clearly echoed in the analogous German expression Richterstaat, or judicial state. So the idea there that judges rule and not elected representatives. But we don't need to take an emphatically positive or negative position from the outset. Judicial activism is namely a factual aspect of judicial power that can even be measured, something that social scientists do. In this sense, activism can be detected in the individual cases in which the judiciary exceptionally departs from its more restricted role and sets itself in opposition to the elected branches. For these cases to be pulled together into more than just individual exceptions to the rule, there must be some indication of a common approach that has gained support either horizontally or vertically. So horizontally, several district courts may, in a relatively uniform manner, interpret legislation related to, for example, public order in a way that does not fully acknowledge the measures that government has granted the authorities to control public gatherings. So this is an issue that is being discussed in the UK at this very moment as well, but it hasn't gone to courts yet. In such a hypothetical case, the courts have considered free speech and the right of association more significant than the government's public order agenda. Vertically, an appeals court may, on the other hand, align these horizontally relatively uniform decisions by specifying that public gatherings involving divisive hate speech should not enjoy the broader protection of these core rights. So from a research point of view, it's worth noting that this type of judicial alignment does not only take place through precedent, but also through and in networking opportunities like training events that give judicial professionals more informal ways of striking a common chord. This is sort of like one under-researched area, is the way in which the personnel, or sort of the way in which justices, judges and other personnel, obviously, in the courts, how they come together in certain sort of like network meetings and so forth, and how they basically sort of exchange ideas amongst each other, and how that might possibly affect the ways in which the decisions are henceforth then made. Now, in addition to competence, the exercise of judicial power also requires the judiciary is independent in relation to the elected branches. By referring to its independence, a court may occasionally justify testing its limits and interfere with affairs that, according to a disagreeing view, belong to the elected branches. In the hypothetical example mentioned earlier, such a disagreement could occur if the elected branches claimed that interpreting primary legislation on public order in the described way would go against the delimited area reserved for judicial decision-making, that the details of the interpretation overstep the boundaries of application. Historically speaking, judicial independence was first associated with the court's impartiality in relation to the parties of the process. The association with the elected branches is of a later origin. In the second sense, judicial independence was recognized as a constitutional principle only after the Glorious Revolution in early 18th century England, after the independence of common law judges in relation to the monarch had been acknowledged in the 1689 Bill of Rights. Independence also played an important role in the development of the rule of law because it enabled the courts to secure the rights of individuals and incorporated entities who were litigating against the state or government authorities. How could the independence of the courts, in principle, basically applying laws passed by the legislator with deference, be justified? Shouldn't judges merely be slaves to the law, as the French expression have expressed it? The key argument, resembling Hamilton's notion of the least dangerous branch, was the paradoxical claim, usually attributed to Montesquieu, that judicial power is not power at all. Montesquieu namely believed that if all judges were appointed from untrained laymen on an ad hoc basis, so without either a permanent judiciary or a professional legal elite, then a judicial power that is not associated with either the state or a profession would be, as he said, invisible and null. If this were the case, then individuals who acted lawfully would do so out of respect for the law and not for fear of the authorities. This was the reasoning behind the claim. Even though Montesquieu's idea of unprofessional ad hoc courts never gained support, his idea of a judicial nul pouvoir lingered on. its echoes can still be heard in the persistent delusion that the adjudicator's decisions in the courtroom somehow resemble a logical model of subsumption, even though the factual basis of that logical model was easy enough to falsify, sort of basically to show that this is not the way in which judges actually think or decide. It had important social and political consequences. An automated logical machine cannot have a will. And by the same token, it cannot use power. In this way, the judiciary could be distanced from the political institutions as independent and impartial. Any discussion about judicial activism begins at the point where we perceive the judiciary to have a will of its own in relation to the elected branches. In contemporary times, the clearest way for the judiciary to express its independent will is through constitutional review. As the reviewers of the constitutionality of primary legislation, the judiciary departs from the narrow definition of an applier of laws that the separation of powers doctrine implies. In executing constitutional review, the judiciary can, using Alex Stone-Sweet's vocabulary, interfere either directly or indirectly. These direct and indirect mechanisms also resemble Mark Tushnetz's distinction between strong form review and weak form review. The interference of a disagreeing judiciary is direct when it specifically refers to its constitutional competence to do so. If the court's decision, moreover, has a legislative status comparable to positing legal norms, as in the case of the German Federal Constitutional Court, the judiciary even becomes a disagreeing negative legislator, as Hans Kelsen critically described the role of constitutional courts. So basically what you have is this type of logical contradiction that Kelsen and obviously Kant before him sort of were so afraid of, in the sense that you have two supreme legislators at the same time, which is a logical impossibility. In the UK, the Declaration of Incompatibility specified in Section 4 of the Human Rights Act 1998 is an example of a more indirect mechanism. But even in that case, the public confrontation between the elected branches and a disagreeing judiciary may be politically embarrassing, especially for the former. In the so-called Belmarsh case from 2004, the House of Lords, as the then highest court in the UK, held that the detainment periods contained in Section 23 of the Anti-Terrorism, Crime and Security Act 2001, so we are now in 2001, which was that sort of threshold year, were incompatible with Article 14 of the European Convention because it made discriminatory distinction based on nationality. Even though the Human Rights Act only offered the judiciary the opportunity to declare that incompatibility in an advisory capacity, its consequences were factually more significant in the sense that the declaration did lead to changes in the law. So advisory statements can lead to factual changes. And this has been the case sort of ever since. So if you follow up and look at all the different declarations that the courts in the UK have given, usually they are followed by a change in the law. So they are sort of, they have authority, which is basically sort of not codified anywhere. Even before the legislative changes were made, in this particular case, the court's decision immediately sparked a more general discussion on the need to limit the powers of the judiciary, a discussion that has continued in the UK since. And I think sort of we are now sort of once again in a fairly sort of calm period because the internal dynamics of the court have changed since, the Lady Hale and her sort of group has now sort of like exited, and there is a new, shall we say, new legal culture in place. The Human Rights Act offers a good example of the difficulty in distinguishing direct mechanisms from more indirect ones. But more apparent indirect influencing can take on many shapes and forms. The judiciary is often invited to participate in public consultations concerning planned legislation. Already at that stage, the judiciary may signal its preferences, even what it would be willing to accept as constitutionally acceptable. In some jurisdictions, like our native Finland, sort of my native Finland, Päivi's Finland, the constitution grants the highest courts, in our case, the Supreme Court and the Supreme Administrative Court, the possibility to independently propose new legislation to the elected branches in areas where they deem reform to be necessary. In addition, the judiciary has become a proactive media agent as it has embraced the media artifacts that the contemporary world offers. Most high courts already have their own communications officers and social media handles. The recent launch of the German Federal Constitutional Court's Instagram account is perhaps taking yet one step further. There was a big hullabaloo about the Instagram account. In all three cases, that is the consultations, the proposed legislation, and the communication services, we can fathom a boundary line at which potential disagreement with the elected branches can actualize. So it can actually sort of also be, it can function in such a way that the disagreement has already taken place and that the judiciary responds through one of these mechanisms without actually making a decision of any sort. So it's not sort of like direct confrontation, but they might say, for example, that fine, we made a decision, we made this decision now, but that we find that the law should be changed, it should be sort of reformed, et cetera, et cetera. They might say that in a public statement or in a consultation statement that deals with the same thing. Simply that there's sort of one of the sort of like footnote arguments here is that in terms of the judiciary, there's much more material to research than simply the decisions. You know, if we focus on the decisions, we get a bit sort of like, we get a rather narrow view of what's happening. There's this type of sort of socio-legal focus on all the different communications that a court gives, plus of course the decisions, gives a sort of much richer view of what's happening there, also in terms of the separation of powers. Regardless of the nature of the interinstitutional disagreements, activism is seen as problematic due to the majoritarian principle embedded into the constitutions of most liberal democracies. This principle would make an activist judiciary a counter-majoritarian institution, as the American expression puts it, operating without a democratic mandate. But if the elected branches are supported by a democratic majority that has given its mandate in elections, why would they feel obliged to tolerate an independent judiciary in the first place that can, in the worst case scenario, even actively prevent its will from materializing? Political scientists have made a distinction between internal and external explanations. According to internal explanations, the ability of an independent judiciary to openly disagree with the elected branches can even benefit the latter. In the hypothetical examples mentioned earlier, the judiciary has several channels with which to signal its views on the need for reform in advance. Legislation often requires a spark before things get going. And these factual channels of influence are a way for the judiciary to convey its views. One such channel is, of course, a certain uniformity in judicial decision-making as well. So, you know, we don't have to discard these sort of traditional views there, but there are many more that we can look at. External explanations, on the other hand, are premised on the idea that the judiciary itself has political authority that delimits the possibilities of the elected branches to act freely. So if there is a high enough public trust in the judiciary, the elected branches that are dependent on the same public as an electorate are also more inclined to respect the views of the judiciary, even if it may mean abandoning initiatives that have been high on the political agenda. Even defining the meaning of a majority is not as simple as it may first seem. If the judiciary uses its authority to signal its disagreement with the appropriateness of a particular piece of legislation, what majority would it be acting against? Theories of liberal democracy usually only refer to the majority as the electorate that has given its mandate to parliamentary representatives in elections. Italian-born political theorist Pasquale Paschino, on the other hand, talks about the way in which a democratic majority can be seen as two separate entities. On the one hand, we have a represented majority, or in other words, a proportion of the electorate in whose name parliamentarians act and whose will they exclusively interpret. This is the people that individual parliamentarians represent. So these are the people who voted in the elections, in the previous elections, right? This is the majority of the people who voted in the previous elections. But democracy includes another more sort of factual majority that need not be the same as the represented majority of the electorate. The elected branches may, for example, propose legislation in the name of the majority that it represents, that a factual majority, however, opposes. Referendums and other forms of direct democracy are one way of acknowledging the simultaneous coexistence of two different majorities, a represented one and a factual one. The two majorities do not then necessarily go hand in hand. And the more time has passed since the last elections, the greater the distance between the two majorities tends to be. American constitutional theorist John Farragon claims that the judiciary, and especially the highest courts, may have an important democratic role to play in bringing these two often opposing majorities together into deliberation about contentious issues. The judiciary would, for example, or could, for example, signal to the elected branches that legislation should be updated to correspond with the views firmly held by the factual majority. The courts often occupy a privileged position from which they can observe the real-life consequences of outdated legislation, like the suffering that an unnecessarily rigid interpretation of social welfare law can cause to those in need of help. In this sense, the elected branches may even be dependent on the information that the judiciary transmits from the grassroots level. In this example, the judiciary would hold that a less rigid interpretation corresponds with developments in what's called public opinion that the political elites may be totally alienated from. This is the claim of often sort of made in the US that, you know, from Washington, you can't really see what's happening at the grassroots level. I'm sure the same thing is said about Brussels. I'm sure about Amsterdam. I'm sure about a number of other places too, that the capital city simply doesn't know what's happening, especially the elites, and the capital cities simply don't know what's happening at the grassroots level. Certainly in universities, we can say that the university managers have no idea what's happening at the grassroots level. But often the deliberation is directed by the judiciary into the opposite direction. The courts, namely, often make unpopular decisions to pave the way so that public opinion may find official political positions more acceptable. For example, the 2015 US Supreme Court case, Obergefell versus Hodges, had such a social function to the extent that it initiated a broad political discussion about same-sex marriages in a politically exceptionally divided country. So allow me to finally sum up things and to bring these slightly disparate notes together into my main claims. So I started off with the general claim that as far as interinstitutional relations go, we can only see what our theoretical premises allow us to see. So if we start off from a fairly standard liberal account, including conventional notions of the separation of powers, we will also end up emphasizing constitutional competences, which do not necessarily give us a very nuanced account of what's actually happening. So instead, I proposed an agonistic premise, which, unlike standard liberal accounts, suggests that all interinstitutional relations are potentially conflictual, even if disagreements don't necessarily always actualize. And yet the disagreements are there, albeit dormant. Next, I discussed how powers are possibly separated among the main institutions in statist and transnational environments. One way of looking at recent developments is to conjecture that all three institutional persons of the political trinity have the same goal of fulfilling a liberal or possibly neoliberal political program. Now, this single program in turn is executed through a constitutional division of labor, where separate institutions share powers, to borrow an expression from political scientist Richard Neustadt's well-known study of the American presidency. So if all institutions strive to accomplish a single political agenda, no separation of powers actually exists, making all claims of checks and balances equally problematic. If there is no disagreement, the unitary trinity will by necessity take on a totalitarian flavor. A more likely account of recent developments is that we're gradually shifting from institutionally tripartite models of government to factually dualistic models, where the executive-led elected branches, or in other words, the governmental majority made possible by a weak parliament and a rigid notion of party discipline, so where the elected branches are institutionally facing the judiciary. If legislative and executive powers are merged into one and concentrated into the hands of a single super institution, and if the function of the legislature seems to be reduced simply symbolizing democratic values that don't necessarily work in practice, then the judiciary finds itself in a new position from which it can rethink its political and democratic tasks. The missing checks and balances between the legislature and the executive, as well as the factually non-existent or weak parliamentary scrutiny of the executive, create a democratic vacuum that needs to be filled. So judicial power may no longer be merely the application of laws in individual cases, but securing proactively that basic rights are respected as power concentrates into the hands of the executive-led elected branches. Now, whether the judiciary is willing and ready to accept this challenge is a completely different story. So thank you very much for your attention.